Welcome friends. Today we are here to discuss a very vital topic in Insolvency and Bankruptcy Code, Section 32A, which was brought in to alleviate all the concerns of the resolution applicants relating to the legacy issues of the corporate debtor. The Section 31, the approval of resolution plan by the adjudicating authority, already provided an environment to the resolution applicants as to how they will circumvent or circumscribe the liabilities, the surmounting liabilities of a corporate debtor when they take over that under a resolution plan approved by NCLT under the process of IBC. But the legacy issues like attachment of assets, the ongoing prosecution proceedings, the defaults and offences committed by the corporate processor in the face of its insolvency, continue to haunt the resolution applicants, and in many cases the enforcement authorities like ED, CBI, Directorate of Revenue Intelligence continue to chase the new management and the corporate debtor for the proceedings that they had initiated, and even issued further summons for initiating fresh inquiries and proceedings even after the takeover by the resolution applicants. This was becoming a very big concern with the resolution applicants and was dampening the investment interest that they sought in the distressed assets, and therefore was becoming a grave concern for the investment climate in the distressed assets market space. Let us see what the IBC initially intended to achieve. The IBC is a complete code for resolution of distressed assets, the companies in distress, by way of reorganization and beginning in a mechanism of insolvency resolution. One of the foremost objectives is that the process is to be run in a mechanism by providing an environment that the value of the assets can be maximized and interest of all stakeholders is balanced. One of the vital stakeholders who bring in the value realization aspect of the IBC is the resolution applicant, and they are very much concerned when some investigating authority keeps on questioning them of the past proceedings, the past of the corporate debtor. They wanted a clean slate to start with the process of revival of the corporate debtor, and if such a clean slate can be provided, there would be more interest in the assets, more people will be able to and willing to participate in the process of resolution, and when there will be more participants, there will be competition, and thereby the value of the assets would be maximized. Let us have an overview of how the IBC process operates, and then we will place what is the relevance of Section 32A in achieving that. The IBC process at the first and foremost stage puts the management of the assets of the corporate debtor, the business of the corporate debtor, in the hands of an independent professional, that is the resolution professional appointed by the NCLT. This helps in alleviating the concerns that if an investor is willing to take over a company which is in distress and revive it, he doesn't have to deal with the ex-management. The custody of the assets will be with an independent professional. He will have to deal with the resolution professional and committee of creditors, and he can be rest assured that resolution professional will hand over all the assets of the corporate debtor to him in a good state. Second pillar of the IBC is the process of inviting claims. This helps in building a information memorandum, assessment of what all liabilities the corporate debtor has attracted, whether they are well represented in the balance sheet, and even if they are not well represented in the balance sheet, there is a process of public announcement. Anybody and everybody who has a claim against the corporate debtor, that can be made to the resolution professional, and he verifies it from the records of the corporate debtor and makes a compilation. Resolution professional also does the task of ascertaining all the aspects related to business and assets of the corporate debtor, makes a compilation of that, and develops a white paper on the corporate debtor, the business, the assets, the processes, the tangibles, the intangibles. This helps a potential resolution applicant to ascertain what all is the asset value, what all is the business value, and what investment proposition he can make to the corporate debtor, to what all investment he can make for revival of the corporate debtor, what all things he will need to do, what are all the gaps, and he gets a good starting point for his deep dive diligence so as to come up with a resolution plan. The IBC is designed as a market-led process. The opportunity that is there for revival of a corporate debtor which is in distress is placed in the public. There is a process of invitation of expression of interest. Anybody who has the wherewithal and meets the criteria approved by the committee of creditors can put in an expression of interest. And in the marketplace, who all are the eligible applicants? They come up with their best ideas, best resources, and make their best case for revival of the corporate debtor through submission of a resolution plan. Amongst multiple people who make the proposition for revival of the corporate debtor by way of a resolution plan, the committee of creditors enters into a process of negotiation, picking up the best resolution plan in terms of the proposition, in terms of the settlement of the stakeholders, in terms of the feasibility and viability of actual implementation of that resolution plan. The best suitor, of course, finds the favor with the committee of creditors. Committee of creditors, through a vote of 66%, approves the resolution plan. And of course, thereafter, since this is a quasi-legal process, there is a requirement of approval of the adjudicating authority, which is National Company Law Tribunal. National Company Law Tribunal reviews the entire process, sees that all the processes were duly followed, all the stakeholders' interests as guarded under the law have been protected, the valuation exercise has been carried properly, all the checks and balances have been verified by the resolution professional, and it has been duly voted upon by the requisite percentage of vote by the committee of creditors. Now, the significance of the approval of adjudicating authority comes by way of provisions of section 31, which provide that once it is approved by the adjudicating authority, the resolution plan will be binding on all the stakeholders. Now, the implication of this is that an investor, a resolution applicant who is presenting a proposition for revival of a corporate debtor does not have to go and individually settle with all the stakeholders and negotiate on a one-to-one basis. Once the resolution plan submitted by him is approved by the adjudicating authority, that becomes binding on all concerned. No individual can stand up and say that he does not accept it. At best, the remedies go to NCLAT and file an appeal. And this feature of section 31 that makes it binding on all concerned enables the resolution applicant to circumvent his liabilities, obligations, and the investment that he has to make and commitments he is making in respect of the for revival of the corporate debtor. Therefore, he can very well envision what will be his commitment, what is the financial outlay, and then evaluate what is the prospective return that he can get out of the corporate debtor and endeavoring in the of his assets for revival of the corporate debtor. But one concern has still remained and struggled. All the liabilities, the contracted liabilities, the legal contractual debtors, the contingent liabilities, all that can be covered under a resolution plan. But what does the the resolution applicant do? What his obligation or what his stake would be if there is a ongoing prosecution proceeding against the corporate debtor and there are fines and penalties, and in certain cases even prosecution for directors and management is also provided under such statute. If those implications are also attracted by virtue of his investing in a distressed company, that will be a very unpromising and unwelcoming situation for him, and a large number of resolution applicants would get disinterested or shy away from making any proposition, and would feel that since they are good businessmen, they have never committed any offense, why they should get into such hassle of getting the investigating proceedings and feel the consequences where they have not done any wrong. IBC, when it was enacted on 28th May 2016, it did not address this grey area and this concern of the potential investors or resolution applicants. IBC Amendment Ordinance 2019 was brought in on 28th December 2019, which subsequently culminated in IBC Amendment Act 2020, which was brought on 13th March 2020. And the amendment that was brought to address this grave concern was Section 32A. Section 32A was brought to address two concerns. The first concern was regarding the ongoing prosecution proceedings, which could result into a certain penalty or sentence, and the repercussions against the assets of the corporate debtor in which the resolution applicant or the investors are actually making the investment. So Section 32A seeks to address both these concerns. It seeks to provide immunity to the resolution applicants, the bona fide resolution applicants, to that they will not be prosecuted against, or the corporate debtor, if any prosecution proceedings are going on, they will not be continued against the corporate debtor. And secondly, if the assets of the corporate debtor have been made subject to any attachment proceedings, that attachment will automatically go off, and those will not be subject matter of attachment anymore. Of course, Section 32A, when it was brought in, it had this object in place, but with checks and balances, that scrupulous people who try to get back their companies after having defaulted on the loans, who were actually party and responsible for the offences in the first place, they should not get scot-free. They should not use the process of approval of resolution plan and immunity provided under the Section 32A to get rid of their offences. This is what the objective of the Section 32A when it was amended. It was to provide immunity against prosecution of the corporate debtor, to prevent action against property of such corporate debtor and successful resolution applicant, subject to fulfillment of certain conditions. Now let us see what these conditions are and what is the ambit of protection of Section 32A. The first leg of Section 32A subsection 1, as I mentioned, the first aspect is the concern of the resolution applicants that a company which is in distress, a company which has been in hands of a management who have been charged of siphoning of funds, of wrongdoings, of non-compliance of provisions of Act, and in many cases of insolvency, a company which is in distress, it will more or less fall into a backlog of compliances, which then would attract penal provision under several acts like Companies Act, Income Tax Act, Excise Act, and so on. All these legacy issues, once the company is taken over, the resolution applicant has invested his money, he has brought in new sets of hands-on board, new managerial person who have taken over, he is exploring new marketplaces for the product, he is investing into the working capital, he is investing into reviving the operations. He doesn't want to get entangled with the investigating proceedings and the proceedings jamming the operations, jamming the management bandwidth once again. The immunity that 32A provides, that insofar as the corporate debtor which has been taken over, its liability in respect of any proceedings which were going on prior to commencement of CIRP, that shall come to an end. the section through a proviso further provides that even if during the CIRP some process has been initiated, even that process will come to an end. And this cessation will be automatic from the date of approval of resolution plan under section 31 by the adjudicating authority. So on one hand, the provisions of the resolution plan qua the various claims will put a limitation on the settlement amount that is payable for the liabilities of the corporate debtor. The fiction of the law provided under section 32A, the immunity that is provided, will also bring to an end on an automatic mode all the proceedings, ongoing proceedings that were continuing against the corporate debtor from the date of approval of the resolution plan. Now, certain conditionalities have been provided under section 32A to ensure that this section is not taken advantage of by people who were in first place responsible for commission of those very offences. So to ensure this, certain set of peoples who have been excluded from this immunity are, the condition is the change of management should have taken place. If through a resolution plan the management continues to be the same and the same very person are managing, and this is very much possible because now under section 240A the for MSMEs certain MSME companies, the promoters have been exempted from certain clauses of section 29A, so they can very well come back into management, and certain managements may not be ineligible for putting up resolution plan. But in case the management change is not happening through section 31 plan, then immunity of section 32A will not be available and offences will be prosecuted as they would have been as if there has been no change of management. In case the investigating authorities have reason to believe that certain persons are responsible for the offences, those persons will continue to be prosecuted and the immunity will not be available to them. But this belief, this reason to believe has to be based on material on record. It cannot be a enveloped belief that yes, possibly even the change management could have participated somewhere. If there is material on record that some shareholders, some persons in the new management as well were responsible or could have contributed and there is some overlap, and investigating authorities can make their case that they have material to substantiate their belief, the proceedings can be continued against them. As mentioned, it doesn't protect the designated partners in case of a LLP or a officer in default in case of a corporate person for the offences. Now friends, the objective of the immunity is to protect the resolution applicant who has a bona fide proposition of investment, a commercial investment, and provide him a clean state and encourage more and more resolution applicants to participate in revival of the corporate debtors. However, the intent of law is nowhere that the proceedings should come to an abrupt end. The proceedings will very well continue against other persons who have been responsible for the offences, but for the corporate debtor, and for investigating if any cooperation is solicited or any records are solicited from the corporate debtor, the resolution applicant, the new management, they have an obligation to provide the assistance that may be required by the investigating agencies. The next leg of immunity that is provided by section 32A subsection 2 is qua the assets of the corporate debtor. Now for most resolution applicants, this is even more significant and immediate immunity that they required. In fact, this immunity emerged, the requirement for this section emerged from developments in certain large insolvency resolution cases where the resolution applicants had already taken over the corporate debtor. However, they were not able to take complete charge of the assets of the corporate debtor because certain investigating authorities had attached the assets of the corporate debtor, and thereby the resolution applicant was put to grave prejudice that the very assets for which they have invested the money, they are not able to realize those assets. The assets for which they have done their due diligence, now certain investigating authorities or certain other authorities have come in who are seeking a prior claim or attachment against those assets. The significant feature of section 32 is that the immunity not only applies to assets of the corporate debtor taken over under a resolution plan under section 31, but it also applies to assets of the corporate debtor which have been sold by a liquidator as part of liquidation estate of the corporate debtor, and some person has invested in those assets under the liquidation process. Now, this is also not a blanket immunity. If the assets transpire to the same management, the resolution plan is not envisaging a change of management, and previous persons are only going to be under the management, this immunity shall not be available. If the investigating authorities specifically have any reason that yes, so and so person is claiming immunity under section 32(2), however, this person has perpetrated the offense or has collaborated in the offense, and his presence or charges can be framed in the proceedings against such and such person basis on the material available on the record, that exception is carved out from the section, and that person can very well be continued to be prosecuted. Friends, when there is law, the compliance and adherence of the law is a matter of public policy, and if a immunity is brought in, it is seen as a protection being given to a certain persons for the offences which need to be prosecuted, which is seen by many in the public eye as an aberration to the public policy or strict compliance of the law. When section 32A was introduced, it also met with similar challenges. The very constitutional validity of section 32A was brought into question by way of a writ petition before the Honorable Supreme Court. The basic contention was that if there is law, there are certain compliances to be made, there are certain offences which have been perpetrated. Those should be brought to the logical conclusion by way of punishment. Otherwise, it will bring in leeways and mechanisms to non-compliance, and law will not be followed in its strictest sense. However, in this case, Manish Kumar versus Union of India, the apex court has diligently gone behind the objective of the parliament behind bringing the section 32A, which is deepening the distressed investment market in India, bringing in more resolution applicants, so that there is larger number of resolution applicants taking interest for a particular distressed corporate debtor or its assets, being assured that they will not be falling into trap of legacy liabilities nor in trap of legacy proceedings. The assets that they are investing will be protected by immunity provided under law. And what this will help in maximization of value by increasing the competition in the marketplace. So the Supreme Court rightly observed the objective sought to be achieved, at the forefront of which is maximization of value of assets. This objective cannot become the subject of judicial veto on the ground of violation of Article 14. So the apex court upheld that section 32A has been brought with a certain objective. That objective is very well aligned to the public policy, which is creating a deeper market for distressed assets, for early resolution, for maximization of value, and therefore it does not violate constitution. The law has been tested, and enforcement agencies, as they would have shown reluctance to let go of their investigative powers against the resolution applicants. There have been proceedings wherein the courts have sought from investigating agencies as to their take on why they should continue, the investigating proceedings should be continued against the uh, persons whom they are claiming that the investigating proceedings should be continued, being the new management. The investigating authorities, the ED in this case, had a very generic response that as of now they cannot give a clean chit to the new management. They cannot not sure whether these persons will be required to be prosecuted or they have any role here, and accordingly the prosecution should be allowed to be continued. But NCLT said no. If you have any reason to believe, if there are any reasons, you bring it on record. Otherwise, the new management will be exempted, and accordingly, exemption was granted. In another case, Tata Steel BSL Limited, the cogurance of Section 32A was very well taken by the adjudicating authority, being the Delhi High Court in this case, and they acknowledged that there is a resolution plan approved by adjudicating authority in place, so no prior proceedings for offences can be continued, and thereby discharge the corporate debtor of all the proceedings. Since the jurisprudence is developing, there is one case law, interesting case law, in case of Varsana Ispat, which has come in context of liquidation proceedings. In this, the NCLT has clearly adjudicated that even in case of liquidation, even if there is some asset which has of the corporate debtor which has been subject matter of any attachment, liquidator can very well sell that asset, and once it is sold under the liquidation process, the successful purchaser of the asset will get that free of the attachment, free of all encumbrances. So friends, you would have seen that Section 32A provisions and the immunity provided by them for the bona fide resolution applicants, not for the persons who were party to committing the offence, not for the persons whom can be believed to be the offenders in the original place, and whom the investigating authorities have reason to believe that basis on some material that they need to be prosecuted. This has deepened the distressed asset market by bringing in more and more resolution applicants, by giving them confidence that legacy issues will be legacy issues and they can have a clean and fresh start, and therefore they can be rest assured about their investment. Thank you, friends. That was all that I wanted to share with you on Section 32A of IBC. Thank you very much.